Hello friends, welcome to Tarun IAS. Today we will be discussing editorial analysis from the Indian Express of 12th of December 2022. So let's start with the editorial. The editorial is about the poor under trials. Basically, it's about the under trial condition in the Indian prison. So we will discuss about the Indian prison, and I will also tell you to link this article with one of the previous editorial that we had discussed, and you can go to our playlist of editorials and check out that editorial. It will be highly beneficial for you to prepare this topic. You can relate it with your syllabus General Studies paper 2, that is Judiciary, Laws, Mechanism, Institutions for Welfare and Development of the Vulnerable Sections of the Society. Now let's start with the editorial. This editorial has been written by B.B. Pandey, who is the professor of law at Delhi University. And what he wants to say, we will discuss it. Now, why this article has been written? Because recently, our President Draupadi Murmu, she had raised the plight of under trials on the National Law Day, which is 26th of November, which is also celebrated as our Constitutional Day, and especially focusing on Jharkhand and Odisha. Now, according to the writer, the NCRB report has also said that the figures with respect to the under trial prisoners have risen in last decade, and the sad state of the under trial, it was brought to the attention of the court in the 1970s and 1980s. Wherein in one of the cases, in fact, in the series of petitions, doctrine, it was evolved, and that was the public interest litigation, that is PIL. This public interest litigation was brought forth to the people of India in a series of petitions that were filed by a lawyer, an advocate, Husainara Khatun. In the case of Husainara Khatun, which led to the amendments in the Code of Criminal Procedures and Code Practices. Now, what is this PIL? We know that anybody in the PIL case, the locus standi doctrine or locus standi provision was done away with. That means the aggrieved person need not to be present in the court to fight for the plight or to advocate for his or her case. Anyone on behalf of the aggrieved person can fight the case or can advocate in the Supreme Court or High Court or any other court in the Indian judiciary whatsoever. So this was the concept of PIL that was brought in 1970s by Husainara Khatun case and also by Justice P.N. Bhagwati. So what the writer wants to say, the writer says that the government has tall claims with respect to decolonization and decriminalization. However, the colonial panel, it continues to rule the roost. We still have not been able to get rid ourselves of the colonial legacy or the colonial rules that still entrenches the Indian Penal Code and Criminal Procedure Code of India. Now, the writer basically points towards the three sections of Indian Penal Code, and that is section 124, which we all know it is famous for its sedition. However, this section, it continues to mar the post-independent India. Even after we have decolonized or we have freed ourselves from the colonial rule, we still have the colonial legacy in the form of sedition law, that is section 124A, which was basically formed during the struggle of India so as to suppress any national activities, and which these national activities, however, to free India from the colonial rule, but the British government or the British colonial rulers, they thought of it as anti-national activities, and this is the reason why section 124A still continues in the Indian Penal Code or still finds place in Indian Penal Code. The next section the writer points towards is the section 186. Basically, this section gives power to the public servant against the obstruction in discharging of his public function. And the second section and next section is section 188, that also gives power to the public servants for disobedience to an order which is lawfully promulgated by the public servant. So these are the three sections which are basically the important sections when we talk about the conditions of the under trial, and when we also talk about the state of the prisoners in India or the state of the prison in India. If you look at the report, the prison statistic report, then you would find that there is the prison in India, they are highly congested. Prisoners in Indian prison, they do not have legal access. They do not have access to the medical institutions and medical facilities. And especially when we speak of the under trials, then there are cases where the under trials, they have even served the sentences for which they were not even convicted, they were only accused of. So more than even the sentence that was supposed to be awarded to them if they had been convicted for that particular case, they have served more than that. So this is the reason the writer wants to talk about and brings our attention to the conditions of prisoners in the Indian prison and also the state of Indian prisons. Now the writer says that post-independent, there are several statutes which are designed to control and repress the behaviors that are outcomes of the social and economic tensions. However, see, most of the time what happens, we have punitive laws. We have also got laws for the preventive detentions. Now, what happens, even if somebody has not committed that crime, that person has to be arrested, because what if in the future that person commits the crime? So basically, in order to prevent the person from committing the crime in future, he or she is arrested in present. So this does, according to writer, this does not make sense when there can be other non-punitive measures to serve these purpose. So the writer says that though the center is working on the new draft of IPC and CRPC, and there are proposals with respect to the reforms in CRPC, and if we also consider the Ranveer Singh panel, which is basically has been constituted to review the CRPC, this has raised high hopes to end the colonial legacy, especially when it comes to the legal or jurisprudence that we follow in India. So it is considered that the power to arrest is often adopted as sine qua non. Sine qua non means something imperative, very important, significance to good governance. Supreme Court in Arnesh Kumar case in 2014 put a highlight when it comes to the arrest. However, largely we have failed to achieve the purpose. That in Arnesh Kumar case, it was said by Supreme Court there should not be any unnecessary arrests. We have to avoid unnecessary arrests. We cannot just arrest a person and put them in jail. Jails will be crowded. They would become overcrowded, and it would pose another situations, such as there are in fact cases. In fact, on 10th of December, when we were discussing about the conjugal rights, then the state government of Punjab had highlighted this issue of having cases of homosexuality amongst the inmates, where they are not given right to meet their partners, where their conjugal rights are infringed. So we did talk about the conjugal rights, and there are clashes between inmates if it is highly crowded, if there is no hope to go out, if there is no reformity process. In fact, the person even feel even more depressed when he or she goes to the prison to serve their sentences. So we should not have retributive justice. We should not have repressive justice. We rather should have reformative justice. We rather should focus upon reforming the person so that these people can then become part of the Indian society. They can again normalize their life, can again put them into the mainstream employment, jobs, etc. So the focus should be on reformation rather than retribution or repressive justice. We should have a reformative justice. So in fact, if we consider the case of lockdown in the year 2020, then the migrants, they were treated under section 188. So let us talk about the case of Tamil Nadu. Now in Tamil Nadu, more than 3 lakh homeward marchers, they were arrested and they were put in jail. And like I said, they were treated under section 188. And Supreme Court definitely took the suo motu, that means the self-action, cognizance of the marchers' petition, and passed an order for their release. So this is what the situation has been. There are unnecessary arrests. Now the second thing that we would come to is about the bail provisions. If there is an arrest, there should be bail provision. However, for a person coming from the low income background, the bail is hard to get. Bail is not a norm in India. It's rather based on conditions. So in fact, like they say, jail, not bail. It has become the rule here. So in the recent report that was published in the Indian Express of 26th of November 2022, it revealed that 5,202 alleged militants were arrested in Assam between 2011 to 2021. The police basically relies on first schedule of the section 188 and recognizes some of the actions as cognizable. So right to bail basically is a safety valve that provides a person an assurance to have a hearing before the court or the judiciary agency that is going to examine the executive action. If we speak about the bail, then there are very difficult bail conditions which are put up by court. For example, the surety bonds are signed, monetary bonds are signed so that the person does not run away. And these monetary bonds, they are hard to fulfill by the person coming from the lower ranks of the society or from the lower income group. So therefore, Supreme Court recognized the personal bond in lieu of the surety bail in Motiram versus State of Madhya Pradesh 1978. Section 436 1B of the CRPC talks about the bail, anticipatory bail provisions, and the court's reluctance, even those who fulfill the condition with respect to the bail, is point to be noted here. So bail provisions are not properly employed here. So first, the writer has spoken about the arrest. So what are the issues that we are discussing here with respect to the state of prison and prisoners in India? The first one, that there is unnecessary arrest. The first one is about the law, the law itself, the statute itself. For example, section 124, section 186, section 188. The second point is about the arrest, that there are unnecessary arrests, for example, in case of the lockdown. And third point is highlighted is the bail provisions. The bail conditions, they are hard to be met by the people from the lower income group, and bail conditions so currently the system is working on jail but not bail. Right. Now, let's talk about the conditions. Now, on November 29, 3 days after the president's remark, a two-judge bench which passed a heartening order in Sanadhar versus State of Chhattisgarh, a state where there is a large number of undertrial, continues to languish the prisons. Even after securing bail, each jail authority would be required to convey to the state government that data in this respect, and the state government would then have to send it to NALSA so that a scheme can be worked out. So this case is to be remembered, that what will happen in case of the Sanadhar, which is the state of Chhattisgarh, the two-judge bench of the judges had said that a data would be prepared with respect to the prisoners in the jail, and then it would be sent to the NALSA, which is the national legal authority of the country, and it provides free of cost legal assistance to the people, especially from the lower income group. So, and then a scheme would then be provided that what are we going to do. So you can link this article with one editorial that we had discussed, and that is the prison reform. And that is the prison reform. All right. So I would provide a link here in this video itself so that you can link both the articles. So what is basically the recourse that is being available here? So let's talk about the recourse then. So the first recourse that writer talks about is the legal assistance. Legal assistance. All right. So this legal assistance is something that writer talks about, and the next thing, and the writer has also given the example that in the late 1990s, thanks to the Delhi University Legal Aid Clinic extension to the prison legal services, there is a unique opportunity that we have got to assure the speedy release of the under-trial prisoners through the prison Lok Adalat. So second thing that the writer talks about is the Lok Adalat. So as the third thing that writer talks about is the legal volunteers, so that people can have these you understand the pro bono cases. These are the cases a lawyer takes up free of cost. So there is no monetary benefits here. Right, so legal service volunteers can be there. The second thing and the fourth thing that writer talks about is is that the bail entitlement and there should be no discrimination when it comes to the bail entitlement. So this is what we discussed in today's article. We talked about the prison reforms, and I would provide the link for the another editorial, and through these two editorials your understanding with respect to the state of the under trial prisons, the prisoner statics report, and what is the Justice Amitav Roy commission has talked about with respect to the prison reforms, and so everything is there in that article. So this is the continuation of that article, so that you can have a better and holistic understanding. So thank you so much for watching Tarun IAS, and if you want to download the PDF of this session, you can go to our Telegram channel. The link will be given in the description below. Have a nice day.